Hello, and welcome to Notes on History. Today is June 8th, the anniversary of the day James Madison went before the United States Congress and proposed a package of constitutional amendments that we now know as the Bill of Rights. So, to celebrate, I'm going to use today's video to provide a brief refresher on the Bill of Rights. I know, you learned all about them in high school, and you probably complained that you're never going to use this stuff in real life. And now that you're an adult, you're constantly dealing with redcoats being billeted in your dining room. But it turns out that's not okay, and you don't have to put up with it. So kick those lobster backs out of your house, or if you're still in school and you need a little study guide, here it is. So without any delay, here goes. Madison actually proposed 12 articles, 10 of which became the Bill of Rights that we know and love today. Plus one more that would be ratified much later on, and one that was never ratified. Today I'm going to talk about just the 10, and I'll describe a little bit about why we have them in particular, starting with the First Amendment. The First Amendment states, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Now, we know this as the guarantee of the right of the freedom of speech, of religion, and of the press, but it's actually quite a bit more than that. Notice how it's worded. The amendment doesn't grant you those rights. It is assumed that you already have them. This simply limits the Congress in passing laws regarding those rights. And I do mean Congress in particular, literally the House of Representatives and the Senate. For example, several states, such as Connecticut, Massachusetts, New Hampshire, had established state religions for decades. Massachusetts was the last to get rid of its established state religion in 1833, not because people thought it was unconstitutional, but because they just didn't like funding churches with tax money. So why do we now have this as something that applies to the states? I'll get to that in another discussion on the 14th Amendment, but understand that taking power away from the federal government was not a protection of the states against the federal government. It was actually a protection of the states from other states. One thing that can be difficult for Americans to understand today is that people in some parts of the country really didn't like people from other parts of the country. They didn't trust each other. Well, maybe it isn't too difficult to understand. People from Connecticut didn't like Massachusetts. People from Pennsylvania didn't like South Carolinians. Nobody liked Rhode Island.
You want to hurt me? Go right ahead if it makes you feel any better.
Sorry, Peter, that was uncalled for. This is easily understood, though, if you're from New York City or California. Would you want Southern Baptists from Texas establishing a national religion? Texans? Would you want East Coast liberals sending a government inspector to decide what you can and cannot say on Fox News? Well, actually, come to think of it, this is actually really easy to understand. Who knew? The Second Amendment is subject to a lot of debate in our time because we just can't seem to agree on what it actually says. My apologies in advance to my more liberal-minded friends because it actually is really crystal clear. Here's what it says. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So I'm not going to get into a big political debate about this. That's the quickest way to turn people off of watching this video. But I will bring up three basic points. In interpreting the amendment, always remember these three things. First, nobody would have thought you should stop people from being able to hunt. That would have been like telling people they couldn't farm. It just doesn't make sense in the 18th century. Taking away typical firearms was never on the table. Second, this isn't like the First Amendment, which specifies that Congress cannot make certain laws. It simply says that the right of the people, the right that they already have, shall not be infringed by Congress or by anyone else for that matter. And not the right of the militia, the right of the people. Because if you have to stand up to your government, where do you think the militia is going to get its weapons? Third, bear in mind that the men who debated this in 1789 had experienced a government crackdown on guns. Does anyone remember Lexington and Concord? Remember Paul Revere's ride shouting, "The British are coming! The British are coming!" By the way, it totally didn't happen that way. But why were they coming? What were they doing? Do they even teach that part in American history classes these days? They were going to Concord to capture and or destroy military supplies stockpiled by the colonists. That's what sparked the actual fighting in the American Revolution. That's why you'll hear pro-Second Amendment activists talk about needing to defend ourselves against the government, because it actually happened. So consider this. Would it make sense for the federal government to regulate the militia whose constitutional duty is to protect citizens from the federal government? It's a little bit like letting the mouse guard the government cheese. If you want a better understanding of the grammar employed here, do a simple YouTube search for Penn and Teller's explanation of the Second Amendment for a pro-Second Amendment video. It's quite good. It just isn't family-friendly. If your tastes lead you to want information on a more pro-gun control video, you're going to want to check out this video here.
Come on, people now, smile on your brother, everybody get together, try to love one another right now.
Foolish humans. Oh, yes, Kodos. Earth is now ripe for the plucking.
Ah, yes, the Third Amendment. Bastion of controversy, destroyer of friendships, scourge of civil discourse, and instigator of bar-room brawls all across this great land. The Third Amendment states, "No soldier shall, in time of peace, be quartered in any house, without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." No, actually, no. I went looking, and it turns out I can't find a single Supreme Court case where a decision was based on this particular amendment. It is the exact opposite of controversial. It's so obviously non-controversial to Americans today. So why would we even have it? Well, it may be non-controversial to us today, but remember, in 1765, in the lead up to the American Revolution, the British government passed what was called the Quartering Acts. This allowed a standing army to be put up in people's homes if the local barracks didn't provide enough space. If the people's homes weren't enough, the troops could also be quartered in inns, stables, pubs, restaurants, and of course, quote, "the houses of sellers of wine and houses of persons selling of rum, brandy, strong water, cider, etc., etc., etc." Because nothing smooths over a standing army in your front yard like depriving those young soldiers of home and women and then getting them all liquored up real good. What could possibly go wrong? On to the fourth. The Fourth Amendment states, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Again, these rights are assumed to already exist, and the amendment protects them rather than grants them. This was deemed important because, again, of the American experience of the Revolution. It is so important to understand that smuggling was the great American pastime. The new nation was a nation of smugglers. That's why the British had trouble enforcing their various taxes. It's why when Jefferson imposed his embargo when he was president, he imposed an embargo in the early 19th century, he shut down trade rather than try to regulate it. He knew it was just too darn easy for Americans to get around the law. Now, the British saw Americans as this guy. But of course, we Americans know better. Search warrants had been abused by British officials in the colonies, and this amendment was simply written with that in mind. A lot of discussion is surrounding this amendment. especially in discussions involving lawyers or police officers, but quite frankly, it really is this straightforward. The Fifth Amendment, the Sixth Amendment, the Seventh, and the Eighth Amendments all have to do with the court system as well. The Fifth is a long one. I'm going to sort of go through these ones pretty quick because they're pretty, in many cases, pretty self-explanatory. The fifth one is a long one, but don't worry, it's actually much more boring than you might think. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor to be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. We think of this as the right to plead the Fifth, and thanks to a 1966 court decision, it's also the reason why the police are supposed to read you your Miranda rights. Now, fair warning, I'm not going to do the Fifth Amendment justice. There are several items here that I do want to point out if you're a student studying for finals. Otherwise, there's just too much here to go through in a short video. So just remember these. The Fifth Amendment talks about a few different protections. 1, you have to be indicted for serious crimes. It's sort of an extra step, but it's an indispensable one. 2, no double jeopardy. If the prosecutor can't make their case stick the first time, they can't keep trying until they find an agreeable jury, with very, very few exceptions. 3, pleading the Fifth. You can't be forced to testify against yourself. That's what they mean by that when you see someone in a legal drama pleading the Fifth. Due process. This just means that legal rules must be followed to the letter. And eminent domain. That's the part where it says that the government can't just take away your property without paying you for it. This is something that has been subject to abuse, especially in recent years, but that's a discussion for another day. The Sixth Amendment. Here's what it says. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. This is actually pretty self-explanatory. Moving on. The Seventh Amendment is not quite as self-explanatory. First, the text itself reads this. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. This is the right to a trial by jury in federal civil cases. The $20 issue is a little strange. It really isn't quite clear why $20 was the figure that was used. No one really pays attention to that figure. $20 in 1789 is over $500 today, according to www.officialdata.org. But courts typically don't worry about this under $75,000 anyway. The Eighth Amendment states, excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. Now, this one is actually straight out of the English Bill of Rights from about 100 years before. The language is pretty darn similar. The English law in question grew out of a case where a man named Titus Oates, who lied under oath multiple times, this led, by the way, to the wrongful execution of people who Oates had accused of various crimes. So he was a pretty terrible guy, but when they sentenced him, his punishment was considered just too extreme. Look him up on Wikipedia if you want the details. That's where these particular pictures came from. This same language made its way into the Virginia Declaration of Rights in 1776, and then they sort of hopscotched its way into the Constitution a little over a decade later. Now, the Ninth and Tenth Amendments are particularly interesting. and it's very, very relevant to the political conversation today. Here's the 9th. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Put simply, the fact that a right isn't specifically mentioned in the Constitution cannot be used as an argument to say that you don't have that right. You may not actually have that right, but not finding it mentioned in the Constitution can't be the reason for someone to tell you you don't have the right. So, if someone says to you, you don't have the right to wear orange shoes, well, why not? Well, I've read the Constitution, and it can't find anything in there that says you can. Sorry, no. 9th Amendment. The 9th Amendment's much better known big brother is the 10th. This one is of real interest today, especially to constitutional conservatives. Here's what it says. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. Now, the United States is understood to mean specifically the federal government. So, this should present you with a moment of extreme cognitive dissonance. The vast majority of what the federal government does simply isn't in the Constitution, so the 10th Amendment would imply that the federal government today doesn't resemble a constitutionally approved entity. And yet, laws are very, very rarely declared unconstitutional on 10th Amendment grounds. Why? Well, usually laws are written in such a way, and or the courts interpret them in such a way, as to stretch the Constitution to cover things that the Founding Fathers would never have intended or anticipated. But that's another video entirely. If you like this video, please be sure to like Notes on History on Facebook, or leave family-friendly comments below. Of course, I'm also a professional genealogist. I actually haven't posted in the last week because I've been busy doing research for clients. If you'd like to be one of those clients, please let me know by contacting me at notesonhistory.org. Thanks for listening.